Okay, here we go. This is part 3. And give me just a second here. I want to re-tag some people in. Got some things posted. Don't know how Facebook works as far as when they get things posted, etc., how people get notified. So one last time here. I think I can wind it up here in number 3. And this is an important part that I really... Some personal information involved here. But I just want you to see what we deal with and why this is such a difficult thing. Then you will either really appreciate what I do even more or call me the ultimate fool, okay? Because that is what's going on. Okay, we're going along here, getting some people tagged in. Sorry to take up so much of your day. I hope you have time to have a cup of coffee with me or something. Or just go back and watch it later. That's fine too, because I'm trying to get these posted everywhere. I share them, put them on YouTube, share them again, upload them to Twitter, get some people. I even sometimes do a little brief, take a little clip from it, put it on Instagram, just trying to make sure that people watch these and we get people educated because so much is going on. Oh, gosh. Okay. Gonna stop right there. One more minute. Very good. Okay. Okay, got a few tags in. All right, so now this is part 3 of September 22nd. This is going to be the last one, I promise, so y'all can get on with your day. But I've just been so swamped the past 3 weeks, I haven't even been able to talk to you. All right, I want to finish up with guardian ad litem. So we have this one article that talks about the curious case of the guardian ad litem. I want to tell you how this article starts. And again, I'm going to remind you that law follows policy, policy follows culture, and you are the culture. Okay, you are the culture. So talk about what is going on. This article starts like this. In 2006, Cameron, a veteran of foster care, was given the chance to speak to the Connecticut legislature about his experience with his guardian ad litem, the attorney appointed to represent his best interest in the abuse and neglect case about him. He told them, "I've been in DCF care since I was 12 years old, but I didn't know that I had a lawyer until I was 18 years old. That was when I found out that I no longer had a lawyer. A lot of the decisions were made for me, and this person went to court to effect those decisions without my knowledge or influence. I wonder how a lawyer represented me if he didn't know me. How can he represent me without knowing what I want? For all he knew, I could have been a girl. I believe that if they want to represent you, they have to know you and meet you." The next sentence says, "The concerns of Cameron The concerns with Cameron shared with the Connecticut legislature are echoed by thousands of children in the child welfare system today. Amen." Foster kids are starting to speak up. We are in second generation. Actually, we're probably in about third generation from the 70s. Yeah, about third generation. But this generation now that are getting out of foster care are really starting to speak up. All right, so this case goes on again. Like I said before, it goes back to historic development of why guardians were appointed for children of slaves, for property rights, etc. Hang on here. A couple of things I marked. This one section says, "The juvenile court movement at the end of the 19th and beginning of the 20th centuries firmly embraced a separate family law for the poor. The need to protect families who were deemed neglected, dependent, and destitute was seen as an extension of the Chancery Court's authority to provide for the welfare and guardianship of children. That authority, in turn, stemmed from the view that the state, as parens patriae, was the guardian of social interest and had the power to act as the ultimate parent of the child. And thus began the guardian ad litem best interest issue." And then it goes on to say, "The indeterminacy of the best interest standard thus increases the risk of arbitrariness." Okay, let me read that again. Very important. "The indeterminacy of best interest standard thus increases the risk of arbitrariness, because state statutes typically provide little guidance as to the meaning or content of best interest, and the child's expressed preferences are not binding or controlling. The guardian ad litem and the judge and dependency courts are free to determine best interest without meaningful constraints. Amen. Amen. Even today, I'm just going to tell you, I read a court opinion the other day, basically saying, speaking of a child who was about 4 or 5 years old, saying that the child had developed, what did he call it? The child believed that the placement, which he had been in since he was young, this has been going on for 3 or 4 years, 3 years probably, the child believed that his placement was his family and had strong bonds with them. And it would be psychologically damaging to remove that child from those bonds. I'm like, how the hell do you know that? Yeah, and you know what? And if indeed that is true, why is DCS snatching kids all the time that have strong bonds with their family? Just saying, okay? All right, so that's about that. All right, so as I told you, I have, and also, I'm sorry, I got one more thing in this little folder here about the American Bar Association. I know we get a lot of people who are disgruntled about their attorneys, but they really need to understand there are resources to look at to help educate themselves and then help share with their attorneys and to get the proper representation. I am one person. I cannot represent 13,000 people that are part of the Family Forward Project. You need to become educated as parents, grandparents, friends, social workers, therapists, to help parents manage the system and understand their rights. So it talks about, with the American Bar Association standards, that, read this, they distinguish, they have a child's lawyer, means a lawyer who provides legal services for a child and who owes the same duties, included undivided loyalty, confidentiality, and competent representation to the child, as is due an adult client subject to Section 7 of the Act. The best interest advocate means an individual not functioning or intended to function as a child's lawyer appointed by the court to assist the court in determining best interest of the child. And then it says, the court shall appoint a child's lawyer for each child who is the subject of a petition of abuse and neglect. The appointment of the child's lawyer must be made as soon as practical to ensure effective representation of the child, and in any event before the first court hearing. The child's lawyer, in addition to the child's lawyer, so they prioritize the child's lawyer as the number one position to be taken for the child. And then in addition to that, the court may appoint a best interest advocate. And it talks about the court may appoint one child's lawyer, his siblings, if there's no conflict of interest. Very, very difficult thing to say because the conflicts are all over the place. Okay. All right, so that is what the ABA says, guys. So you talk about dogging lawyers all the time. Go to the top because it's down to the bottom. Remember, law follows policy, policy follows culture. This is already in our culture, the ABA standards. All right, so one last topic I'm going to go over today, and this is about attorneys. Okay, so actually it's funny the way I came across this. I was looking for my Kershaw case online, and I came up with the fact that in the summer of 2019, there was an attorney by the name of Kershaw in East Tennessee who had been censured related to his comments in the court and his threats against the judge, his use of social media, etc., etc. And so I will tell you that this is a real sensitive issue. If y'all have been watching for a while, you know that the ethics board has come after me for using social media as a platform. And not just social media, actually. They have come after me for the fact that there were parents who went to the Williamson County Commission and spoke about their experiences with Judge Sharon Guffey and how she had basically abused their families and how they felt that, that she was contrite and demeaning and basically ruined their families, took their kids away on ex parte orders, etc. And I told a brief synopsis of the story that I had with my daughter when my daughter was a runaway when she was like 14 years old, and just how I had been treated. And I kind of was willing to blow it off and just get through it. But then more and more and more people started coming. So there were 8 families, myself, I think, and 7 other families that went to the Williamson County Commission a little over a year ago. And we had it all recorded. We got it all uploaded. We had the press there, and we talked. We're very verbal. Well, the board came after me and said that because I had held up a picture of the child, of the person speaking, that I was impugning the judiciary. And I didn't even tell their stories. They told their own stories. And that the story I told about my daughter impugned the judiciary. And remember, this is a public forum where the public can go speak. The county commission, who's in charge of the county budget, the county activities, she's being paid by the county. And so it was the perfect forum for these matters to be heard. And so now they think that there should be a censure against me for that. Also, the other one had to do with a judge. It's a little bit different issue. I'm not going to go into that right now. But it's a judge that has been crosswise with me for 10 years, okay? Some things that he did and I said. But let's just talk about that, whether or not it matters, whether an attorney still has the right to speak out and have a voice and has any First Amendment rights when it comes to just talking generally about matters that occur in court and the judiciary. I mean, there's a huge article that was published by a professor of law out of Indianapolis. Her last name is Tarkington, and she talks about, do attorneys have any First Amendment rights at all? I mean, they are the ones who know the most about what's occurring within the family court system because they're there every day. They see it every day. They have to deal with those attorneys over and over and over, and they're the ones with the most knowledge. And if they see repeated violations, that they should have the ability to speak about that out of the courtroom, as long as it does not interfere with any particular case. And so you have to look at, are the statements made during a court case or after a court case? Are the statements facts or are they just opinion? Are they in court or are they out of court statements? And you have to really nuance this. And although the United States Supreme Court has looked at the press and about the press basically impugning government officials and given them pretty broad discretion for being able to make statements, they really have put a lot of strictures and sanctions on attorneys. So let me tell you, first I'm just going to go ahead and tell you what this attorney did. So first of all, he's in this hearing, and he's in a hearing, and I think it's an order of protection. And so this woman, and again, I don't know the case. I don't know the actual case. And so I'm not really here to render a judgment as to whether or not the actual case had any validity. But I just want to talk about what he did and talk about whether or not I've seen the same thing happen in court before. So the woman was on the stand and she was testifying about the abuse that she had suffered in an order of protection hearing. And so she starts crying at the end of it, and then her attorney stops and the other attorney stands up to start questioning her, and he basically, the clerk had passed some tissue over to her, which they do, and the attorney made a comment about, well, maybe you need to give me one of those tissues too because I'm about to start crying. And then there's another place where the woman talked about bruises, about being yanked out of a car. And he says, well, I guess the angels came and protected you because you had no marks. And then there's at one point where the judge says, I'm losing my patience with you. And the attorney looks at the judge and says, it goes both ways. Okay, now, I don't do things like that. I know I'm very controversial in some ways. I would never say that to a judge, okay? I may say something like, we're very frustrated, or I don't feel like we're getting down to the truth here or something, but I would not do that. However, these things that this attorney has done and said to witnesses in the courtroom, I've heard judges and other attorneys say things like that. I've heard them say things like that to people and be demeaning and be critical and totally inappropriate in the courtroom. This is not the first time this has occurred. This is not like something brand new. And so if we're going to pay attention to it, we need to pay attention to it at all levels. I had a judge from the bench who said that she thought my client needed to reconsider her attorney because that her attorney, me, was more interested in promoting her agenda than representing the client. And said that in front of my client when I asked the judge to recuse herself because she was violating the rules of judicial conduct. So and when I tried to have her sanctioned, they did nothing. They blew it off. They dismissed it. Okay, this is what I deal with in the operation of the courtroom. These are the kinds of things that happen all the time. I had an attorney or judge call me a jerk one time from the bench when I had asked for something perfectly legal relief for my client that was recognized and authorized under the law. And when I tried to have him sanctioned, they did nothing. Okay, so if we're going to go around and sanction attorneys for what they say in the courtroom, which I don't think he did the right thing. I think this guy who's probably, I may just call him one day and talk to him because there's some questions about what's going on in that county. I'm not going to talk about it. But then anyway, the attorney goes out and puts an ad in the paper. And says, hang on, hold on, be patient. He ran an ad in the local paper that said, during the course of the trial, the judge yelled at the attorney in a manner that the attorney has never been yelled at like in his entire life, and that is completely inappropriate in the courtroom. At one point, the judge said that the attorney was testing the judge's patience, and the attorney explained that the judge was also testing his patience because the judge was refusing to allow him to ask questions about clearly relevant evidence. All right, now they found that saying that he was yelled at in the courtroom was a false statement. And so therefore he was sanctioned for that because they listened to the audio and in their opinion it was not yelling. And so he was sanctioned because he said it was false. And then he made a social media post that said, Judge Bailey is, in my opinion, the most unethical judge in the state. And then it said, did you know several judges in Tennessee are unethical, especially in Greene County? So he got sanctioned for some of that too. And it goes through here and it talks about Tennessee rules. And Tennessee, the Supreme Court, it changes. And so in one case back in 2000, hang on here. Bailey, Slavin. Okay, so in 2004, there was a case from the Tennessee Supreme Court, which was a totally different panel of judges who basically gave First Amendment protection to an attorney who made some comments about some judges. And I think that was actually during a court proceeding. And then in 2000, in 2018, and again, this attorney, I think, was way out of control in what he did, but he did some crazy stuff. But in that case, it's called the Parrish case in 2018, the Tennessee Supreme Court made this comment, which is horrible, that says it doesn't matter whether it's an in-court or out-of-court statement. So this is bad. This is bad. This is bad for attorneys in that attorneys are blocked from saying things, okay? Blocked from saying things about what's going on. All right. And yet, in contrast, in the Tennessee Bar Journal, the September 2019 issue, it talks about speak up. Look, speak up. You see that? It says, Tennessee's new anti-SLAPP statute provides extra protections for constitutional rights. And a SLAPP is a strategic lawsuit against public participation. In other words, it's a lawsuit that's filed against you, can be civil or criminal, specifically to shut you up. Okay, so that's exactly what they do, is they go after an attorney who speaks up and they file litigation against them to try to impede their ability to practice law, to shut them up. Okay, so we have anti-SLAPP litigation in the Tennessee Bar Journal that says speak up against your government, speak up. And then we have attorneys being sanctioned for speaking up. So, y'all want to know why attorneys don't speak up? That's why. All right, one final thing then, and I just had to share this. This is totally on a personal note. But, you know, I have been an activist since 2009 when I first went to the legislature, when I saw things occurring in family court that I was very, very unhappy with. And some of my clients went, and some people who were not clients, several people went and spoke to the Tennessee General Assembly when we had a Tennessee Committee on Children and Families. And they abolished that committee shortly after we spoke, because it was a forum for the public to go talk about what was really happening to them. And so they came after me. They decided they were going to sanction me because a judge held me in contempt because I said he was violating the Constitution. He holds me in contempt. I file an appeal. I go to the Court of Appeals, and I basically said that the judge had lied in his show cause order. He lied saying that I advised my client to violate a court order. It was not true, and he couldn't prove it. And we had a contempt hearing. He couldn't prove it, and he presided over his own contempt hearing, which is unethical and is basically prohibited. And the Supreme Court wouldn't kick him off the case. I mean, it was clearly done in 2009 to shut me up. Okay. So then I go through the Court of Appeals, I get it reversed, but because of my brief, I said the judge had lied in his show cause order. They came after to decide they were going to sanction me. Okay, so if y'all look me up, everybody likes to look me up. So there's this like old public censure that I went through this whole this whole hearing about. But let me tell you about that. So the process of attorney discipline is that there are disciplinary panels, and they pick other attorneys to sit and judge other attorneys, right? So on my panel was this dude named Jack Garton. He was an attorney from Dixon County, and he's sitting up there as the head of the three people judging me because I said in a brief that the judge lied when he put a show cause order in the court system saying that I had advised the counsel to violate a court order, which was not true. It was not supported by the transcript or anything else. He had no proof on it, and he decided to sanction me. Well, guess what I just found out? This attorney went to prison for stealing millions of dollars from a trust, and was doing it at the same time that he was standing in judgment over me. Yep. Yeah, so what do you think about that? So a dude who's stealing millions of dollars is sitting on a panel to sanction attorneys, and he decides it's appropriate that I should publicly be sanctioned for saying a judge lied, which he did, in a show cause order. That's what I have to deal with. So, Jack Garton, here's to you. Tennessee Walk of Shame, buddy. Gotcha, okay? Hope you never come back to the practice of law. 6 years in prison. 6 years. Millions of dollars. And you know what it was? A state trooper got killed. There was a trust fund. His daughter got cheated out of all that money. Okay, y'all. Oh, my goodness. I am so sorry it took so long this morning, but I've still got a whole another stack of stuff over there to go through. But I tell you, so I have federal cases pending. Motions to dismiss are coming tumbling in on me. They are so stressful for me to respond to. I have to go like undercover, deep behind the computer, get my little booty on the computer chair, and not come up for breath. Okay, so very, very, very difficult. I don't know what's going to happen with the guardian ad litem issue. It's so important, such an important issue. Things do get reversed. Law changes, conflicts, and constitutional law, my two favorite subjects, okay, in law school, my two best grades. Constitutional law and conflicts. Okay, so to challenge the law, you have to understand the Constitution. You have to understand what's going on. All right, so want to remind you one more time, all of you need to go find that case I talked about in one of the other videos, Shuckers v. Kammer. And I'm going to probably put together a little blog on that and post it so you have access to it there too. Very, very important for you to understand your rights of your children in school, etc., etc. Okay. I am tuning out. Time for me to go fix myself a nice lunch and spend the afternoon with family. Y'all have a good weekend, the rest of the weekend. I hope you're having as beautiful weather as we are here. Hope to see you in California or Alabama. Please stay tuned. Please invite people. Remember, law follows policy. Policy follows culture. You are the culture. Thank you.